A very good evening, one and all present here. I welcome you all in today's webinar, indeed, an interactive session on family law hosted by Asian Law College. It is our privilege that today we have amongst us our esteemed guest, Ms. GEETA RAMASESHAN, a renowned advocate, Madras High Court. Ms. GEETA RAMASESHAN has been practicing since 1982 in Chennai in the area of criminal law and family law. She has worked extensively with the legal aid system and has represented women living with HIV/AIDS, survivors of custodial violence, women and children who are survivors of sexual violence, under trial prisoners, juvenile children, and minority groups that face discrimination. She has been a special public prosecutor for the CBI and has been invited by the National Judicial Academy, Bhopal, to deliver lectures. She is a Heinz Fellow on Comparative Law from the University of Pittsburgh and Eisenhower Fellow on Human Rights, Public Interest Litigation, and Justice, and has been a guest faculty on international human rights law at the University of Pittsburgh. She is an adjunct faculty at Asian College of Journalism, Chennai, where she teaches a course on media, law, and society. She has co-authored a book on child and the law and has written many papers and articles to her credit on legal issues pertaining to women and children. Asian Education Group welcomes you, ma'am. As well, we all are very excited and keen to listen about your expertise and experiences so far. So, without wasting a single minute, I would like to hand over the platform to you, ma'am.
Thank you, and good evening to all of you. And I think it's a great honor for you to have invited me today to share with you a few of my ideas and thoughts on the issue of family law. And I think this is a very interesting and a challenging subject because family law or personal law, as we call it in many parts of our country, though when you study it as family law, but it is called as personal laws in the constitution and in other framework, is that branch that is challenging, fascinating, um, and at times can be frustrating to practice because it holds within its umbrella a whole wide branch, and as you are aware of, not just matters pertaining to marriage, divorce, and custody, but also on marriage pertaining to inheritance, etc. And in this, it also gives us a panoramic view of different customs, cultures, and religions. And in the Indian context, and therefore, at times, as students, you may feel that it is a very daunting area, especially when you address issues of inheritance, understanding the nuances of matters pertaining to inheritance. And a lot of young students whom I have known have always found that bit of family law very daunting. But the fact remains that if you once you look at it not from the dry perspective of just reading it from the bare act, but you also kind of understand the way the nuances work in its application, you will find that it is a very interesting area. I believe that family law is also interesting in various other ways. One is that this is the one area of litigation where emotions play a huge part.
Indeed.
And that whether it is a matrimonial discord, whether it is an issue pertaining to custody, whether it is a partition suit, the challenge is huge amount of emotions that actually permeate within the area of family. And the challenge then becomes, how do you box these emotions into the framework of law? Law says, yes, this is what you are entitled to, X amount, Y amount, this is your right, that is your obligation. But understanding the nuances and putting these emotions in that framework of law is one of the first challenge that this branch actually um, informs you. The second challenge, I think, is that today, um, you can't actually see family law in isolation. It is seen in the context of criminal law. It is seen in the context of civil law. It is seen in the context of company law. It is seen along with the context of corporate law in terms of HUFs, huge families, division of shares, etc., etc. Therefore, the understanding of this branch cannot be just relegated to exactly one pinpointing area, that this is how it is going to be. You know for a fact that there is a interplay with criminal law when you look at 498A, 406, 420, then Domestic Violence Act, which has which has civil remedies but definition widely within a criminal area in criminal courts. And so that's the other complexity that actually emerges in this area. And in one sense, it is not exactly a very easy area also to litigate or to practice. Now, I don't, since we are just going to have a conversational discussion, right? So I'm not really going to go into what does this law say and what does that law say, because that you are anyway going to be reading in your textbooks when you for those of you who have done family law, you know that that is there. For those of you who are going to do family law, you will be doing that with your in your curricula. But what I want to actually tell you are certain difficulties that are in this process. One is that our system is adversarial, as you know what adversarial means, right? Pitting against, looking at evidence. Who has the best evidence wins. May not always be the truth, may not always be the right thing, but it is a highly evidentiary process. It is also highly adversarial, which means we are constantly in a court of law finding fault with each other. So, this fault finding process of litigation, this fault finding understanding of what this process is, actually flows into our various definitions of family law. So, for example, if you have done marriage laws, you know for a fact that cruelty is a ground of divorce. Now, in order to constitute what is cruelty, if you look at even 498A, which is cruelty, if you look at various other provisions of law, if you even look at domestic violence, now, in order to constitute what is cruelty, you have to, the spouse who makes that allegation will have to prove that cruelty. So it's completely fault finding. So when you're making out your case, you have to say that these things are what has happened, etc., etc. When in fact, in some situations or in many situations, the relationship may actually be very gray. There could be good and bad things. But if you, for example, go to your lawyer, or when you go back to practicing law, if you were to, for example, write out in a petition for divorce, let's say, write out the good things that happened in the marriage as well as the bad things. What do you think? The court will say, or the lawyer would say, you can't do this, because if you were to do this, then the judge will say there is no cruelty at all. This is just the general wear and tear of marriage. So, appreciation. I come now to the second aspect. One is that the substantive law, which gives you reliefs under certain grounds, is adversarial. You have to find fault with the other spouse when you're looking at matrimonial law. You have to say that the other spouse did those things as defined under the law. So therefore there is a adversarial process. The second process is the evidentiary process. After having alleged that there is this kind of an adversary who is standing opposite me in the court of law, what is the nature of evidence then that I go about giving to my lawyer? Or what is the nature of evidence that the lawyer is actually going to present before the court? There are these very many jokes that abound where, if you see some of those jokes, the client would say, when I read this case, I thought it was meant for someone else. I didn't realize it was my case, because that is how the case would have been built,
Yes,
you
ma'am.
know. So when you take on this method of evidence gathering, the issue then becomes far more complicated. The third area, in terms of how we address or how we understand family law, is that it is not the same for every community in India. Overall, maybe for the in the Hindu Marriage Act and the Indian Divorce Act, which was amended much later in the 2000s, the amendments for the grounds were actually made on par. The special marriage is on par. But if you actually look at, understand cruelty, for example, in both the Hindu Marriage Act and in the Special Marriage Act, the definition is whoever treats a spouse with cruelty after marriage can file a petition for divorce. But if you actually look at Indian Divorce Act and see the definition of cruelty in that law, you will find that it says the cruelty must be so severe that it must be causing a threat to the life or limb. Now, I mean, would a spouse just wait in a marriage, till that kind of a cruelty comes through? Or is there not a kind of discrimination in the way the definition of cruelty is? Should people who belong to the Christian community have a greater degree to prove that that their spouse is teaching them with cruelty? So this is an area again where you have a whole lot of a problem that actually uh, plays itself out in the definition of the law itself. Now, if you were to take uh, the other, if you were to take, for example, understanding equality, let's take, for example, maintenance. Yeah, interim maintenance and permanent alimony. Both only under the Hindu law, the husband is also liable to pay maintenance to the wife.
Absolutely.
This provision doesn't exist in the Christian law, it doesn't exist under the Special Marriage Act. Now, the rightness or wrongness of this can be debated, because, and it is amazing that this kind of what we term as a formal model of equality, which is that all persons are considered equal, without addressing the substantive inequality that actually can address to the vast majority of women. It is surprising that this clause was brought in 1955 itself, without looking at the kind of disparities that a woman may actually face. Let's look at the other aspects of law. I mean, let's look at Islamic law, for example. Islamic law, of course, triple talaq was much maligned. It has now been struck down.
Yes, ma'am.
It is not in existence anymore. But you have one legislation, the Dissolution of Muslim Marriages Act, that applies for Muslim women in case they are not able to resolve their matrimonial disputes amicably. She will be compelled to go to court and file a case for divorce on certain grounds. But unlike other legislations, if she wants custody of her children, she will have to go and seek a remedy under a different statute, namely the Guardian and Wards Act. Because unlike both Hindu law, Special Marriage Act, and the Indian Divorce Act, there is no provision in this to give her interim custody, no provision for interim maintenance, no provision for anything else at all. And this is only restricted to women. So you then have where a woman will have to jump from one uh, litigation to another. If she's lucky and there are proceedings for family courts in her town, maybe all can be within the same court, but different pleadings with different cases. So, then this is where you find the difficulty for accessing justice. Makes it very difficult, because accessing justice becomes variant upon the community to which you belong. I also want to say one aspect about Islamic law. One is that uh, a see, we have to understand two aspects, which I think maybe it does come in most of our textbooks, but I want to repeat that. One is that while all other branches of law actually address a matrimonial wrong, Islamic law is the only one that actually looks at irretrievable breakdown of marriage. Two people can't get along.
Mm.
Therefore, then there is no possibility in making allegations against each other. Therefore, part. In its application, however, the law is highly discriminatory, at least in its application in India, because of the way triple talaq was understood, and because of the way there is still a lot of uncertainty about what is the wife's rights when it comes to a divorce. When it comes to whether she's entitled to alimony, whether she's entitled to only 3 months money, 3 months iddat money, etc., etc. So her rights on divorce are still very unclear, and that is the area where we actually need to work, rather than actually. So I make this point because I don't want to vilify a branch of law which is getting vilified a lot, except to say that it is based on the irretrievable breakdown theory of marriage. In its application, it has become highly um, discriminatory, and it has become extremely problematic in more ways than one. Now, of course, inheritance, as you know, um, tremendously has variations in all branches of law. Yeah. Um, for example, um, one of the in Islamic law, of course, a woman gets half of what the man gets in terms of her share on inheritance, but you cannot disinherit anybody under Islamic law because you can will away only 1/3 of your property, and the remaining has to go to all the heirs. Whereas under Hindu law and in the and if you are married under the Special Marriage Act, you can actually completely disinherit one person in terms of their marriage. So you inheritance is a whole big area in which I don't want to go now because we're already 20 minutes into my talk, and I think you have a lot of interesting questions to ask, or maybe during the questions I can clarify these a bit more, except to tell you that family law is a great challenging area for lawyers. It is not as if, oh, it's matters pertaining to family. You don't have to think it's not challenging enough. You don't have to think that, there's no, it's not maybe as glamorous as corporate law, etc. But here, at least, you will be your own master when in terms of how you practice. You deal with emotions, of course, that can be draining, but as I told you earlier, the challenge here is to box the emotions into the framework of law. So I stop here because it's 20 minutes now for us to take on the questions. Yeah.
Sure, ma'am. Thank you so much, ma'am. Each and every word that you have said, whatever the knowledge part, everything is very motivating, I must say, and it will be for sure very beneficial for our students. So, as our students are very curious to know more about your journey, ma'am, there are a couple
As
of
a, before
questions.
that, I want to ask you,
Yeah.
which year are the students who are listening to this? Have you all done family law, or you're still going to do?
Hmm, students are from BLLB and LLB batch. So, they are definitely studying this subject. Yes, ma'am.
Some of them have done and some have yet to,
Yes, they
right?
are yet to done. Absolutely, ma'am. Yes, but all the law students are there attending this webinar.
Okay.
So yes, ma'am. So, ma'am, so our students are very curious to know more about your journey. There are a couple of questions they really want to ask you. Very first question to you, ma'am. Why did you decide to get into law? What actually
Ah,
motivated you to enter this profession?
I'm actually now 38 years in the bar. Well, actually, my grandfather was a lawyer, and seeing him talking to his clients and seeing the books, just the books around. As a child, I was very fond of reading, you know,
Okay.
mostly fiction, of course, but seeing that uh, made made me want to pursue this, because I used to he was practicing in rural Tamil Nadu, of course, and I used to listen to him talking to the parties late night, more so when I came to the ninth and the 10th. That's
Okay.
when the interest became stronger.
Became strong. That's really nice, ma'am. Next question. To
I
you.
didn't inherit a practice as such.
Okay.
I was interested in it.
Okay, ma'am.
Yeah.
It's really good to know about you and your story. Ma'am, marriages, I mean, it's very beautifully said that marriages are said to be made in heaven and broken on earth. How far do you agree, especially in compliance with the present matrimonial laws in India?
Uh, I mean, let's look at marriages are made in heaven concept, yeah, because matrimonial law will come only when you have a problem, right?
Mm,
Okay, everybody marries with the best of intentions,
yes,
and people will always be talking about increasing rate of divorces, etc. But if you actually take the like if you take for example a big city where in a year there may be 4,000 cases, maybe a bit more, like if I talk about Chennai there may be 4,000 a year, plus some other cases if you include, maybe if you include all domestic violence everything, even if there are 10,000 for a
ma'am.
population of this city, that's really nothing, right? Second is that people divorce, they still want to find another spouse in a marriage. People are remarrying also. So I think the faith and the belief in the institution of marriage is very strong. Now, when it doesn't, now, earlier, of course, marriages are made in heaven is a concept that has come into its language from, say, uh, Shastric law. If you were to use the uh, marriages, complete marriages cannot be broken at all in terms of Shastric law, or marriages are made in heaven in terms of Christian law. But the fact remains that it's ultimately a nature of relationship, in the Indian context, nature between relationship between families also, and there are stresses and pushes and pulls. So I think you believe in that, but sometimes if it doesn't work, it's better to take a reality check.
Well said, ma'am. Indeed. Next question to you, ma'am. You are personified for your work in upholding the right of women and gender issues. What, according to you, is the true meaning of feminism?
Oh, that's a very, that if you actually understand feminism, there are theories and theories. My essential idea of feminism is where there is equality in terms of political, economic, and social sphere for all genders, irrespective of male and female, because now the definition of gender has also expanded. But I think if you really ask me how, if you actually want to know I think, we never used the word feminism. I grew up in the 70s. We didn't use the word feminism much. We were looking at it as women's rights. And there was this whole um, josh to actually look at women's rights. It was post emergency. All of us had that,
Mm,
wanting to come and do something for social norms. And that was a time when I think we didn't think much for ourselves as rights.
yeah.
It was more looking at the larger community rights. So my earlier work has always been on socio-economic women's rights and then crime against women with various women's groups.
Okay, ma'am.
Then feminism, theory, etc. came much later.
Okay, ma'am. So, ma'am, students are really interested in knowing what is the biggest challenge as a litigator, especially when negotiating relationships within the framework of matrimonial law.
Okay. One night I told you first is boxing emotions.
Hmm.
Okay. The second, I believe, okay, now there are different kinds of pleadings. As you know, there can be exaggerated pleadings, there can be pleadings where all kinds of things can be said which may not be true. Okay. Now, that's not something I would ever do. Of course, ideologically and with for my own ethics, I will never say anything that is wrong. But I would also want to tell you that falsification in a pleading or exaggeration also in a pleading will not be always cannot be sustained by the party. If you write something in a case where the party actually has not said it in that manner or which actually didn't happen, the party may not, some parties of course may be there bold, or whatever, but most of the parties will not be in a position to defend their position, so you may be actually doing a disservice. So if you ask me first what is the greatest challenge for me, of course boxing emotions.
Okay.
The second challenge for me would be uh, how to, you see, this is a training we receive in mediation. Yeah,
Okay.
courts are concerned with wronging a past. Yeah, courts are concerned with uh, rectifying a mistake done in the past, right? You do something wrong in the past, courts are here to punish you.
Yes, sir.
You didn't do this, you didn't do that, you didn't pay maintenance to your wife, therefore the court will ask you to pay maintenance. So there is a past which is there, which a judgment will give you. Judgment can only rectify what has happened. But how do you make the client or the party see their interests for the future? That is the second challenge. Okay, so shifting their um, views or shifting them from their positions to one of their interest, taking them along is a third challenge. I don't know whether that you understood that, but that's actually a training in mediation also.
Okay, ma'am. So, ma'am, another question. Can you highlight the crucial areas in which litigation are majorly filed in family law? In such a situation, how do you handle them?
Mainly, I can only talk about litigations I do, right? So if you partition suits, all the time fights within families, and of course within matrimonial law, divorce, and the large chunk of it can be dissolution, but with that you also have maintenance, custody, visitation, etc. How do you handle them? um, you mean in a very elementary way, you start the discussion. I would actually like the party to articulate and put it in writing. It becomes a catharsis for them to write what has gone wrong, or what is it that they seek. Not all lawyers do, but I do it. uh, I want the party to do it themselves, you know so
Okay,
that their thoughts come out, and then you know what they actually think, and for them also it's a catharsis.
okay, ma'am. Ma'am, what is the current legal framework on irretrievable breakdown of marriage in pursuant with Article 142?
See, as I told you, irretrievable breakdown of marriage is not a ground for divorce in India. uh, the only Essentially, you have mutual consent where both parties have to agree for the divorce. Both parties have to jointly appear before the judge, and after a period of 6 months have to jointly also tell the court that they are willing to end the marriage. Now, irretrievable breakdown is a concept where the court, where the ground is that one party goes to court and says they can't get along, they can't live in this marriage anymore. There's no ground available. It's almost given, except in some systems, maybe in the US, you may ask for counseling or mediation, but there too it's a given end. Now, this does not exist in our system of law, except as I told you, the theory in Islamic law, which understands this. Now, what the Supreme Court has done in a series of judgments is that because the litigation has taken years and years and years, by the time it reaches the Supreme Court, they have introduced this as a principle only under 142 and said that we now feel that there is no possibility in keeping the marriage intact, and in the process have granted various rights to the parties. One judgment says that this is possible only under 142, and other, it cannot be followed by other courts, though some earlier high courts have dissolved the marriage, because by the time it comes to the high court it can be 10 years, 15 years, etc. Now, this was introduced as a bill some time ago, but then finally it was dropped, because see, there are two problems with this ground. One is, yes, it can end a very acrimonious litigation, which can go for 10 years. I mean, if you can go up to the Supreme Court, you can afford a lot of fee, you can engage, you have a lot of wherewithal. But if you were to take, for example, rural India, now, if this ground is made part of our law, any husband can just file a case in the court and say he doesn't want to live with her, the marriage is broken down. So then there is no cushion. No, you can just dissolve the marriage like that. So therefore, it's still a confusing ground. You can understand why you would want a ground like this, because it is so acrimonious a litigation. But at the same time, you can also understand what can be the difficulties in introducing a ground. That's why it's restricted as of now only to cases before the Supreme Court. But I think, to my mind, high courts in given cases should also have the power to do so.
Okay, ma'am. So, ma'am, one very interesting question. Like, we all have somewhere heard that, parenting is a very tricky job. So, recently, the Supreme Court in Smriti Madan Kasangra versus Perry Kasangra 2020 held that pampering is not parenting. So, how far do you agree? And in continuation to this question, how far is the theoretical approach of child custody and child adoption is different from the practical approach?
If you ask me, I didn't touch this in my initial talk. This to me is one of the most emotionally drawn areas of work, because it's there is a parental interest and there is a child's interest. Now invariably, now there can be violence where the father can be very cruel. The child has witnessed violence, the child can then be very traumatized. Then there is the insecurity. One ground can be violence, one can be the parent with whom the child is extremely insecure, because he or she feels that if the child goes there, the child may stay away there. The third is manipulation. Either parent wants the child to be with them, and whatever, however much, uh, you know, our parent may rationalize that this is not the way they should be, emotions just take you over.
Yeah.
So, you are emotional, you are upset when the child goes to meet the other parent, etc., etc. And the child senses the parent much more. The child wants to keep both parents happy. So there is a greater burden on the child, where the child, this is at least in the Indian context, where the child feels very overwhelmed in wanting to please the parent with whom the child is. So rather than the child enjoying the flow, the matter gets reversed. The child becomes an adult. And at some stage, the child also starts manipulating. Okay, this is just a tip of the iceberg on the kind of problems that actually happen in the court. Yeah. Now, we don't have the concept of joint custody, which is there in other systems. So there is one primary custody with one parent. The other parent can have equal rights, whatever station, etc. Some parents today, if they are able to sort out their dispute, enter into MOUs of joint custody, elaborate MOUs. But still, the primary parent will be one. Now, what happens is three issues. Courts delay in granting even a visitation. By the time you file something, go to the court, it will be at least minimum 4 weeks, if you're lucky. Within that time, there is enough space for the other parent to manipulate. So that happens at one level. Okay. So then the whole area is so acrimonious that sometimes, unless parents are forced to, understand where they stand, this is going to be, for example, this particular judgment that you refer to. If you all have read the judgment, you all will find that the acrimony is, every paragraph and line is acrimony there. And it's also an intercontinental case, litigation, Africa, India, London. But every line is acrimony. The whole dispute is acrimony. He can't see, I can't see, you cannot see, you're a drunkard, you're an alcoholic, you don't take care of the child, you don't do this, you don't do that. It's a classic case of how you can actually um, pressurize the child so much. Now, on this line about pampering is not parenting, I think that makes a lot of sense because, invariably the father, in most instances, is more wealthy than the mother. And the father, sometimes this happens in many cases. We see when the child goes to the father, the father gets the child a lot of toys, spends a lot on the child, takes the child out everywhere, which the mother sometimes is not in a position to do, because the child meets the father over weekends, the mother has the child over weekdays. And in that time, the child then starts feeling, aha, I can get things there.
Yeah.
Sometimes this happens also, no?
Yeah.
So in that way, that is a pampering which a parent does.
Mm.
Okay, so that, I think the observation of the court in this is that merely because you have 20 rooms and 30 rooms, in that case they had so many rooms, merely because you have so much of wealth and you are indulging your child, that does not mean that that is actual parenting. So I think parenting involves a very different kind of skills. Or one last word on that. I think, to my mind, in child custody matters, you
Mm.
need a lot of intervention from child psychologists in the legal process. I feel that judges are overwhelmed with the problem, and I think that is a lot of a stress on them. And every day you're dealing with 100 litigations of acrimonious kinds, and then suddenly you have to look at a child. It's very stressful. Definitely not just for the child, you need a child psychologist. Parents must be asked to go to psychologists to understand how to deal with their children on separation.
Indeed, ma'am. Very true. I think if I would, say something on this, like, from psychological perspective, in fact, for a lawyer, it's very emotionally taxing. I mean, when you have to deal with such cases. So, somewhere definitely, the way you have mentioned about child psychologists and the importance of it, for sure, our students will definitely understand that. Okay.
Thank
So,
you.
ma'am, next question to you is, what is legal recognition of cruelty under personal laws in India, especially in the light of Special Marriage Act 1954?
Well, I think Special Marriage Act, Hindu Marriage Act, I already said this in my presentation, so I don't want to repeat. Both in Special Marriage Act and Hindu Marriage Act, the definition is the same. It's only in the Indian Divorce Act which talks about life and limb, cruelty to the life. And therefore, I think that's why, as I said, why should cruelty be different for different people,
Mm.
for different religions? There has to be a common understanding of what is mental cruelty and physical cruelty. Physical cruelty everyone understands, of course, but majority of cases come within the framework of mental cruelty. If you come from a family where no bad words or no four-letter words are used, you will be very shocked if you are married into a family where everybody is using it,
Yeah.
right?
Yes, ma'am.
So that's difficult for you to take. The spouse feels that that is a cruelty.
Mm.
So, that understanding mental cruelty becomes far more complex
Absolutely.
in terms of how we, actually look into. But I think you need to push the boundary to newer areas.
Very true, ma'am. Ma'am, what is the role of NGOs in safeguarding the rights of women, children, and old age people?
Each becomes separate, I mean, if you're looking at it in the context of family law, right?
Yes.
If you look at uh, how where women's groups, their intervention in the litigation process is very important, because if women do not have the support system, if of approaching the legal system, their intervention till the end becomes very important. And of course, with reference to the elderly, see, now you have lots of NGOs that are specializing in all these areas, right? And many of them take their people who come to them through all these processes. And I think um, areas in cities, you have lots of them, lots of the NGOs working in that area. But in a rural area, now let's take for example, in a rural area, a physical access to the court itself will be difficult, right? If you're in a village, how much can you go to a court? If you're working in the field, how much leave can you take? So then what is your safety? So in all those areas, I think the intervention is very important.
Okay, ma'am. Ma'am, what recommendations can you give to make legislation pertaining to the rights of child and women more effective in India?
Implementation, every time we always say that everything has to be done within a time framework. That's a constant. uh, every statute that you look at, it will say within 6 months, within this time, everything should be done, but nothing ever happens. Yeah.
Yes.
And um, one I would think is that um, more um, alternate dispute resolutions such as ADRs are becoming very common. But I think lok adalats, in my opinion, leave a lot to be desired. Okay.
Yes.
It's just in certain cases it's very good. For example, in insurance claims, etc. Lok adalats are a great point to settle disputes, land acquisitions. But in terms of family law, lok adalats have to be strengthened in different ways, in more ways than one. That is, of course, for the judicial process to come. As far as legislations are concerned, I believe we have a plethora of laws right now. And maybe, the American Bar Association has a method where they actually, every 10 years, they um, scrutinize the impact of a legislation, you know, and then bring out papers, bring out this thing, and then suggest any changes if required. Now, we actually don't have any of that. We have excellent research, of course, in various branches of law and in various legislations, but nothing as concrete in that manner. So unless something comes that way, where we can then look at a law for 10 years, every 10 years we see where the law is, where it stands, what are the flaws. Just bringing in more and more new laws in a fast manner is not going to help us at all. But to me, again, that is not to the government, that is to, maybe our associations. Yeah.
Absolutely, ma'am. Indeed. Ma'am, we all have heard a lot about the Sabarimala temple and
Mhm.
issues related to it. So, very common question from every student I'm getting that. In one of your articles named Busting Myths about how Sabarimala came to ban impure, what is your opinion on the judgment? Do you think
I
the
don't know how many of you have ever read that article. I was quite surprised. I'm quite surprised that you've found out about that piece, because even I had forgotten about it.
so
Uh,
do you
what
think
was
the
your
judgment has once again discriminated against women on right to pray?
Well, the review is still pending, right? So we need to see how it plays itself out. See, again, here, um, I believe that every woman must be allowed to go to the temple, right? I mean, no, sorry. Yeah, there should be, this is a age discrimination also, because you can't decide who is pure and impure. And the question is, if you have read the article, you will see where I make a point about how
Hmm.
can the state decide pure and impure? It's not for the state to decide. And, but uh, the pitting of two rights, the religious rights, the rights and the and the rights pertaining to women, and the rights on equality. How does that one stand? I mean, if a customary practice is discriminatory, why can't it be struck down? For example, there are so many practices um, which have been all the time found to be not correct in law, and they have been struck down, but so many practices continue to be done in temples. But at the same time, addressing going into every religious practice of every temple is also problematic, because it's too huge a country. You can never um, you know pinpoint that in various ways. But I think I hope the review is upholds the judgment. So we
Yes,
need to see.
definitely.
Review has not stayed, I think. It has not stayed the judgment. So it should be there.
Okay, ma'am. There is a flood of questions and everything, but I'll take a very one question here. Ma'am, our law mainly focus on only two genders, especially. What do you think that there are challenges faced by LGBTQ plus community or third gender in our personal law?
There is this very interesting judgment. Have you seen? I forget the judgment of the Madras High Court, the Madurai bench of Justice Swaminathan, where he interpreted Section 5 of the Hindu Marriage Act in terms of a marriage between two transgenders. And he said that Section 5 talks only of marriages between two Hindus. It doesn't say a male and a female. And he has upheld the marriage of the transgender. I forget the cause title. You can easily find that. Yeah. And that's a very progressive judgment if you actually look at it, because in its interpretation, it permits marriages under Hindu law of transgenders. Uh, so, sexual discrimination includes sexual orientation, which is the judgment in Naz and Navjot. Yeah? The term prohibition of sexual discrimination, sex discrimination, sorry, includes sexual orientation. That has been the judgment in Naz and in Navjot's case. So we are pushing the boundaries, I think. The first has been to strike down 377,
Yeah.
and we should be soon seeing a legislation that will legalize same-sex marriages and marriages among transgenders and other sexual minorities. We have to wait for that, of course, because obviously that will what give a lot of rights under civil law, right? It will give civil rights to parties to, you know, legitimize their relationships. But yes, till that time comes, the Madurai bench judgment is something people should use. And you should actually try to search for that and use it in your class. Or if I have it, I'll send you the copy.
Sure, ma'am, definitely. Ma'am, as we have almost reached to the end of this very interesting webinar, there is just one last question to you, ma'am. What advice would you like to give to all our aspiring would-be lawyers?
Okay. Now, today you have a far greater option than we did in our days. Those days we only had litigation, nothing else. Maybe, once were to do a master's, or then maybe do even PhD was uncommon, and one actually then went off into teaching. But today it's almost as if sky is the limit for a law graduate. But I would encourage you all to enter litigation. Litigation is fascinating, it's exhilarating, it can be frustrating, but there'll be no point when you will actually ever get bored of work. Okay, so I think that's one of the areas where you all should consider. But of course, if you all want to look at other options also, maybe, but you have a far greater option. Don't feel disheartened. I also want to add one thing. Don't ever feel disheartened when you enter litigation. You may feel that, it's not sufficiently paid, laborious, it's boring. But it will not be like that. It will transform you in various different ways. Okay. So I wish you all the best. If this is the last question.
Ma'am, I'm sure that our students must be feeling really highly motivated and inspired by your words, ma'am. Like you said, one thing that sky has no limit. So that's very, very true. And definitely, whatever your words, your knowledge, and whatever you have shared with us, they will surely implement all these learnings in their lives. So, on the behalf of respected chairman, directors,
Best.
deans, HODs, faculty members, our dear students, and the entire AEG family, I would like to extend my heartfelt gratitude to you, ma'am, for enlightening us with your knowledge and your time. We would also like to present a
You.
memento as a token of thanks, ma'am,
Thank you.
for you. Thank you so much, ma'am, for your time. And Asian Education
Thank you.
Group looks forward to a long-term association with you. Thank you so much, ma'am.
Thank you very much.
Thank you.